Makindye Chief Magistrate's Court has started hearing the case in which Vincent Mbowa, the NRM candidate for the position of Councillor LC5 for Makindye III, is challenging the election of Paul Kato of the National Unity Platform. He argues that Kato was illegally nominated and the Electoral Commission failed to follow the proper legal procedures during the nomination process. According to the petition, the alleged irregularities during the nomination rendered Kato's candidature unlawful. Mbowa's lead lawyer, Didas Mohinda, said his client is awaiting the court's ruling on whether it has jurisdiction to consider issues raised in the petition, including objections regarding the response filed by Kato's legal team. Argued that Kato's lawyers Julius Sekade and Joshua Komboy filed their response outside the time allowed by law. Mbowa also alleged that some candidates who were nominated on the NUP ticket were not residents of the areas they sought to represent and only changed their addresses after being declared winners.
Kitegeeza ebeera gundi fomu ebeera nfu. Ekyokubiri bannaffe abamu bwe baamala okwesimbawo ebisanja biri ebyaggwa ebitundu baabivaamu kandi badda buzzi nga omanyi bayita kigumaaza mu bantu nga badda buzzi ne babeera mu bantu nga kakati ku luno bakomawo ne beesimba naye nga beesimba etteeka ligamba olina kuba nga oli mu kitundu ekyo ng'osula.
Baddira ne bagenda ne batagenda mu bantu bali qualified kuba konerako stamp nga ba commissioners ng'etteeka bwe lira
commissioner for oaths
ne bafuna stamp yonna gye baagijja ne beekonerako. Abamu bakozesa stamp nga sina za balamuzi, abamu bafuna stamp nga nga si za balooya, abamu bafuna stamp nga za balooya naye nga bazeefunidde nga bo.
He accused the Electoral Commission of failing to adequately verify candidates' qualifications and residency requirements during the nomination process. Mbowa further criticized the Commission for defending what he described as irregularities that occurred during nominations ahead of the 2026 elections. Mohinda also asked the court to investigate what he described as a delayed response by Kato. He said the petition had been properly served on Kato through WhatsApp and his personal email address. According to Mohinda, Kato's denial of receiving the petition through WhatsApp should not invalidate the service.
When we are effecting service, there are modes of service. It can be by phone, it can be by WhatsApp, as per the recent decisions which are coming in court. So for us, we are saying we effected our service via WhatsApp and the documents were received and blue-ticked by the first respondent. That's our.
The lawyer cited a previous High Court decision by Justice Bernard Namanya Sekana, which held that an illegally nominated candidate could be disqualified from an election. However, Kato's lawyer, Julius Sekade, disputed the claim that his client had been properly served through WhatsApp. He told the court that while Kato received the petition by email, did not receive it through the phone contact cited by the petitioner. Sekade argued that although the law provides 7 working days for a response to an election petition, time should not be treated as the decisive issue in the case. He further submitted that because the Local Governments Act does not clearly address the matter, questions regarding timelines should be guided by the civil procedure rules. Electoral Commission's lawyer Electoral Commission's lawyer also opposed the petition and questioned why Mbowa participated in the election if he had concerns about the nomination process. He also argued that any objections to a candidate's nomination could have been raised before polling day rather than after the election results had been declared. Magistrate Fiona Babirye decided after hearing the submissions to adjourn the matter until August 19th when she will deliver her ruling. William Uranga, Beg Television.